All right, let me paint a picture for you. Let's say you're driving down the road. You're not swerving. You're not speeding or anything like that. You're driving down the road. You got your windows down. You got your music playing loud. You honk the horn a couple times, like maybe you're pounding on your steering wheel with the beat, whatever it is. You're a very animated person. You're driving down the road. A police officer sees this activity and he turns around to follow you. You're almost home. A little bit before you get home, the police officer turns on his lights. You don't see those lights. You turn into your garage, you turn into your driveway, drive into your garage, and then you start to close the garage door. The officer stops his squad car, gets out, sprints up, and stops your garage from closing. He then enters your garage on the suspicion that you are violating a noise ordinance and that you failed to stop when he turned on his lights. Should the officer be allowed to enter your home? This is the question. California police and all of the California courts say, yeah, they get an automatic pass to enter your home because you didn't stop when they turned on their lights. The Supreme Court, in a 9-0 decision today, said, no, that is not an automatic exception to the Fourth Amendment's requirements. And this is a big case. Not only did the Supreme Court say that, they said it in a 9-0 unanimous decision. Another unanimous decision coming out of this court, because this should be basic law. And the fact that the police and all of the California courts disagreed is really shameful, in my opinion. But that's me. This is a good case. This is a very important case. This is about Fourth Amendment protection from government overreach, from intrusion into your home. There is a warrant requirement to enter your home for a reason. Let's talk about the reasons that exists. Let's talk about what the requirement is. Let's talk about why this case is important. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, hit like, subscribe, turn on your notifications. Make sure you don't miss any videos. Okay. So we're talking about the case of Lange versus California. Lange? I don't know. Lange or Lange, L-A-N-G-E. Not sure how they pronounce it. Versus the state of California. And the situation is largely what I described in the hypothetical. So let's check out what the court wrote down. Then we'll do a quick review of Fourth Amendment requirements to enter into a home. And then we'll talk about how this ruling went. This case arises from a police officer's warrantless entry into petitioner Arthur Lange's garage. Lange drove by a California Highway Patrol officer while playing loud music and honking his horn. The officer began to follow Lange and soon after turned on his overhead lights to signal that Lange should pull over. Rather than stopping, Lange drove a short distance to his driveway and entered his attached garage. The officer followed Lange into his garage. He questioned Lange and, after observing signs of intoxication, put him through field sobriety tests. A later blood test showed that Lange's blood alcohol content was 3 times the legal limit. We have to take a pause here because a lot of people are going to be tempted to say, well, he was driving under the influence. The officer needed to address that. That is, a couple things. In some states, I'm not sure how California is, but a first offense DUI is actually a misdemeanor as well. So that doesn't really change the calculus. If he's no longer driving, he's no longer a danger. And that is ample time to acquire a warrant to enter into the home. But that's a step too far. This officer does not indicate that he suspected Lange of driving under the influence until after he entered into the garage and began to question him. He was not driving in a manner that made the officer think he was driving under the influence. So, at least not according to the facts that we have here. So we don't get to say that an officer pursuing a person convicted or suspected of driving under the influence is exercising some sort of right to enter into the home. Again, that may be a felony in California. I'm not sure. Doesn't really matter here because it's not part of the calculus in whether or not he could enter into the home. It is, however, the basis for the charge and the conviction. The state charged Lange with misdemeanor driving under the influence. Oh, see, it's a misdemeanor. It's right there. Lange moved to suppress the evidence obtained after the officer entered his garage, arguing that the warrantless entry violated the Fourth Amendment. Superior Court denied Lange's motion and its appellate division affirmed. the California Court of Appeals also affirmed. It concluded that Lange's failure to pull over when the officer flashed his lights created probable cause to arrest Lange for the misdemeanor of failing to comply with a police signal. And it stated that Lange could not defeat an arrest begun in a public place by retreating into his home. The pursuit of a suspected misdemeanant, the court held, is always permissible under the exigent circumstances exception to the warrant requirement. The California Supreme Court denied review. So then it went up to the United States Supreme Court from there, and they disagreed with all of the California courts. We're going to talk about that ruling in a minute, but let's briefly talk about what the requirements are for a Fourth Amendment entry, a Fourth Amendment compliant entry into a dwelling. All right. And an attached garage is part of the dwelling. A detached garage may not be. That's a different question. Again, not at issue here. But to enter into a dwelling, an officer, a government agent, without the consent of the homeowner, because you can give consent and they can enter, whatever, that's a different question. Without consent of the homeowner, an officer may enter into a dwelling only upon probable cause that there is criminal activity and a warrant, or probable cause that there's criminal activity and a valid exception to the warrant requirement. That's it. Those are the two things. And the valid exceptions are pretty limited. In this case, exigent circumstances is mentioned, that there's some circumstance that precludes the ability of an officer to reasonably obtain a warrant to go ahead and effect an arrest or to pursue someone who is fleeing, for example. Now, this does not apply in felony cases. Felony suspicion is a valid exigent circumstance. A pursuit of a felon, hot pursuit of a felon, very important. Hot pursuit of a felon is an exigent circumstance suitable for an exception to the warrant requirement. So if you have a suspicion of a felony, someone's fired a gun at someone in public or whatever, the officer's chasing them, they're in pursuit, the person runs into a home, the officer can enter into that home to continue the pursuit. If the officer shows up after 15 minutes, we may not have hot pursuit anymore. If 15 minutes is still hot pursuit, is 30 minutes, is an hour? These are the case-specific Fourth Amendment questions that would need to be analyzed when that happens. But generally, hot pursuit is pretty apparent. It's immediate. The person is usually right behind the person. They lose visual contact right when they enter the house, but they see them enter the dwelling. Like there's some knowledge of what's going on here. It's not like they're showing up much later and heard a rumor from someone that they entered in, right? Like they know that they're in there. This is an exception to the warrant requirement. Another one would be suspicion that there is serious, imminent danger of serious bodily injury or death going to happen to someone inside the home. Like the police show up, there's some sort of situation like a domestic assault situation that's going on that they got a call about. They can probably enter the home in that case without a warrant because they've been called to the scene or whatever, and they see the signs, maybe they see through a window, whatever it is. If they have those types of things, they can enter into a home without a warrant. But other than that, they cannot. They must get a warrant. Yes, there may be a criminal. The criminal may be laughing at them right on the other side of the window. They still need to get a warrant. And today, warrants don't take all that long, especially in bigger cities. They tend to have a magistrate on call 24 hours a day that can do warrants by, basically email through a smartphone or something like that. The police officer makes a sworn statement, and then a warrant is issued and they're able to enter, and they can secure the location before the warrant gets there. But that is a hurdle to police officers, and it's designed to be. So that's a very important sort of point about how the Fourth Amendment works and why this is an important decision. Held under the Fourth Amendment, pursuit of a fleeing misdemeanor suspect does not always, that is categorically, justify a warrantless entry into a home. Again, it can, it might, but the circumstances have to be on their own justifiable. So the misdemeanor is not justification by itself. They have to meet the other factors. Again, a felony is justification on its own. A felony is justification if they're in pursuit. Again, if they just go up to a home and they're like, there's a felon in there, I'm going to go in. That doesn't work. They have to be in pursuit. So the court's Fourth Amendment precedents counsel in favor of a case-by-case assessment of exigency when deciding whether a suspected misdemeanant's flight justifies a warrantless home entry. The Fourth Amendment ordinarily requires that a law enforcement officer obtain a judicial warrant before entering a home without permission, but an officer may make a warrantless entry when the exigencies of the situation, considered in a case-specific way, create a compelling need for official action and no time to secure a warrant. The court has found that such exigencies may exist when an officer must act to prevent imminent injury, the destruction of evidence, or a suspect's escape. May exist. May exist. Not do exist. So that is one of the key points here. And then the other major part of this ruling is the common law in place at the Constitution's founding similarly does not support a categorical rule allowing warrantless home entry whenever a misdemeanant flees. Like the court's modern precedents, the common law afforded the home strong protection from government intrusion, and it generally required a warrant before a government official could enter the home. There was an oft-discussed exception. An officer, according to the common law treatises, could enter a home to pursue a felon. But in the misdemeanor context, officers had more limited authority to intrude on a fleeing suspect's home. The commentators generally agreed that the authority turned on the circumstances. None suggested a rule authorizing warrantless entry in every misdemeanor pursuit case. In short, the common law did not have and does not support a categorical rule allowing warrantless home entry when a suspected misdemeanant flees. So this has been remanded back to the California courts. So what that means for this particular defendant is likely this will go back down to the district court and they will have to make an exigency analysis. And they're probably going to fail based on the facts that are presented in this case. They're probably not going to get there on this. Even though the guy was driving at 3 times the legal limit, seems like he should probably be charged with the DUI. The officer should have stopped, gotten a warrant for entry into the home, or simply knocked on the door. He should have simply knocked on the door, asked the guy to come to the door, gotten his, done an interview either at the doorway or gotten consent to enter the home or asked the person to leave the home, whatever it was that they wanted to do. The officer should have done something differently. Entering into a dwelling is an intrusive government act. And I'm very glad here that the Supreme Court has protected us against this. Because imagine if an officer wanted to enter into your home, all they have to do is manufacture some misdemeanor that you might or might not have committed. Remember, this guy was not being pursued because of his drunk driving. It's because of loud music playing out his car window. That's why the pursuit occurred. That's it. The officer went to pull him over. For what? So the officer creates a reason to pull a person over because maybe violating a noise ordinance. Maybe. We don't even know. The officer doesn't know. Does he have a decibel meter out there? Is this guy actually disturbing the peace? Are people complaining? Are people calling the police about this loud noise? What is going on to justify this stop? We don't actually know. But by initiating the stop, he created a misdemeanor criminal act where the guy is suspected of fleeing, but they have to prove that he had an intent to flee. If the guy simply didn't see the lights in his rearview mirror, he's not necessarily fleeing either. He was not actually convicted of that anyway. He was convicted of the misdemeanor driving under the influence. So this is a great ruling. We need more and more Fourth Amendment protection, and especially with the encroachment of police and government into our daily lives, the Fourth Amendment matters now more than maybe it ever has. And we're seeing Fourth Amendment encroachments all over the place, especially on the digital side. But that's just my opinion. Why don't you guys drop a message down below and let me know what you think. Until next time, thanks for watching. Peace. Peace.